Can we go ahead and get into what you're helping people do?
Sure.
School debt?
Yeah, well, these actions, these faux creditor actions, they apply to any debt that precipitates from the obfuscation, exploitation of our production through the money system, through obfuscation of money. So, a case that I can describe because it's exemplary is a case in Spain. I've been given power of attorney over this case in Spain. I'm not a lawyer. In this case in Spain, I was told 6 months, a year earlier that I might be required to provide help to these people. Mid September of last year, these people who have two very substantial debts were visited by the bank to whom the debts are ostensibly owed, ABN AMRO Bank, which is a European bank. I believe it's headquartered in the Netherlands. Anyway, the debts are these, and we have to understand these things to put all this into perspective. But this family, the gentleman is a few years older than I am. I'm 62. They have this property. It's a small ranch in Spain. They are citizens of the Netherlands living in Spain and have ostensibly borrowed this money from this bank. And understand for what we said so far, money is not actually borrowed into existence. We are the real issuers of money. Therefore, the fact of credit doesn't even exist. So it's only by denial of our right to issue promissory obligations that we are actually, in fact, forced, artificially forced, to borrow money. So, given that we have all that digested and we can put this case into perspective, this property has been held by this gentleman's family since approximately 1930, First Great Depression. It's a small ranch in Spain. They call them fincas. So they have this finca, which has been in their family since 1930, over which time to now it's been refinanced many times. I was to be provided this history. It's been mentioned in conversation. I've never actually received the records of it. They're not really material to the case, but they are material to getting a perspective of the magnitude of the issues at hand with this bank and how they're resolved by a single letter here. Anyway, the last time that this ranch was, or finca, was refinanced, best I can tell, was about 30 years ago, somewhere in the vicinity of 1980 or thereafter. And the debt has been serviced as an interest only loan ever since then. Now, we in the States here will find that, that's an uncomfortable thing to think that since 1980, but this is pretty much standard practice I'm learning in Europe. Nonetheless, at that time, it was refinanced to have a value of 5.3 million euros, and it's an interest only debt, which means that all the payments that have ever been made against that 5.3 million of principal have never been applied to the principal. And we can all imagine how many times that this finca has been paid for just since 1980, let alone since 1930. So that's one of the debts. The other debt is a 1.6 million euro unsecured personal loan, also issued by ABN AMRO Bank. About 6 or 7 years ago, this family, their son, they've got, on their ranch, they've got their own stables and barns, polo grounds. The house is what we would consider to be a mansion. In any case, their son had a polo accident, fell from a horse, broke his neck, and has since been paralyzed from the chest down. Mr. Vanderbrand, who's a businessman, had to quit working to take care of his son, and he took out this 1.6 million euro unsecured personal loan to pay medical costs and to tread water while he wasn't working in his regular endeavors and took care of his son. So we have 5.3 million euros of property value, and we have a 1.6 million euro unsecured personal loan. or approximately 7 million euros of debt at stake here. Approximately September 15th of last year, the Vandebrands were visited by a Mrs. Inga Moonen of ABN AMRO Bank. To the best I can tell, I don't know what her exact job description is, but she must be in charge of repossessions across Europe if she flies from the Netherlands to Spain to visit the Vandebrands and to apprise them to get their personal possessions in order, that they'll be out of their home within a week. So the next day or so, Mr. Vanderbrand contacts a gentleman, Jacob Schott, who's a longtime advocate of mathematically perfected economy in Europe. Jack is also a citizen of the Netherlands living in Spain, a neighbor of Carl Vanderbrand's, and they met each other just sometime over a year ago or so. And Jack had apprised me that I might be relied on to help with his case. So 2 days after Inga Moonen visits the Vandebrands to apprise them to get their personal possessions together, that they're going to be evicted in a week. With 5 days left, we have a three-way conference call. Mr. Vanderbrand gives me his basic situation and gives me power of attorney to interact with the bank on his behalf. What happens, I write the letter that I'm about to read to you, and basically we never hear from the bank or its legal team in Spain since. That's approximately 9 months ago now. No payments have been made. By the time the Vandebrands had contacted me in September of last year, they were more than a year in arrears on both of these debts. Not a payment has been made then since approximately 21 months has been paid, and the last 9 months transpiring since the letter that I'm about to read. This letter presents two questions, and as we would understand from the previous discussion that we've had, those two questions invalidate any claim that the debt precipitates to the banking system. The banking system, in turn, cannot afford to take us to court then in an attempt to impose its implicit claims against the Vandebrands, because if this matter is decided in a court of law on its veritable arguments, then a legal precedent would be established which would bring down the banking system across the world. Now, I have pilot cases since actually 1976 on this same matter, and I found since actually on my birthday, January 14th, 1976, that never does the banking system challenge my arguments, and the only reasonable reason to presume that would be is that, presented as these arguments are presented, that they realize that they will lose and that therefore they can't go to court, because in losing they set a precedent which brings down the banking systems across the world. Now, we can speculate how that's handled behind the scenes, and of course I've done so for many years, obviously, but I'll leave it to your own intuition to imagine how that transpires so that we can concentrate on the matter at hand. I write this letter and it's basically over. We do hear once from the bank, and we hear once from its legal team in Spain. I sent 6 letters to the bank altogether, and the only time they replied was after, I believe it was the 3rd letter that I sent. I sent a letter every 10 days for 3 letters. And they replied that the reason that they didn't answer these questions I'm about to read, there's 2 questions here. The reason they didn't answer was they didn't have a copy of our power of attorney agreement, to which I replied effectively, BS. Mr. Vanderbrand sent you himself copies of my letters, verifying therefore that indeed I had, in my own words, been a granted power of attorney in interacting with the bank and himself, and furthermore since he had provided my 2 questions, there wasn't any legitimate reason whatsoever that the bank not answer to Mr. Vanderbrand himself, but that the bank had no case whatsoever. So we never heard from the bank after I told the bank outright that they have no case whatsoever. No claim whatsoever to either the principal or the interest. They turned it over to their legal team. A few weeks later, I didn't receive the letter from the legal team in Spain because, well, I doubt they actually sent it to me. But Mr. Vanderbrand gets a copy of what they claim to have sent me, and I don't receive for some reason. You can imagine why that would be, of course. So the legal team basically claims that Mr. Vanderbrand has ignored all the appeals of the bank and that he's in arrears and that they have to process this debt immediately, which means, of course, eviction, foreclosure, repossession, and resale of the property. And I...
So really tried to bully him, didn't they?
Yes. But I wrote about a 10-page letter taking this lawyer to school, proving that he was in violation of his oath if he even represented the bank. I spanked him very, very thoroughly. In fact, it's a hysterically funny letter. You never seen a... If I was the legal team in Spain, I would be embarrassed to ever appear in a court of law where that letter might be read in the trying of this case, because I represent the questions that I presented in this original letter and other further questions as well. And they don't answer them. And after I write this one letter back to their legal team in Spain, we never hear. So 2 letters from the bank, or one from the bank, one from its legal team. The bank claims it couldn't answer my questions because it hadn't received a power of attorney agreement, which we immediately... We just had a verbal agreement. We immediately produced a written document, sent it to them, and with my immediate reply, BS. Mr. Vanderbrand sent you the questions himself, including my assertion that I'd been granted power of attorney, implicitly corroborating the fact in the very least. And so then we hear from their legal team. I'd be glad to read all these letters you want. They're hysterical. The final one that I sent to the lawyer, and they've never responded to that letter. And the Vanderbrands are still in their home. Of course, the problem here is that we don't have closure. But the fact of the matter is, the bank is at bay. It cannot take them to court without losing on the further grounds of the 4th plank, which I didn't express. Well, maybe I explained it, but our 4th plank of these faux creditor actions and the letter that I sent to the lawyer exercises the 4th plank. The 4th plank holds that being as the banking system has been allowed this unwarranted and unjustifiable power to obfuscate our promissory obligations to each other into faux debts by effectively issuing an irredeemable promise to pay, that is, what it presumes to be a promissory obligation, for which it makes no provision whatsoever to redeem or pay. Therefore, we as private citizens cannot be denied the like right, and therefore the very letter that I send offers to resolve the debt in the very substance of which it is ostensibly created. So if the court is to decide to sustain the implicit arguments of the banking system, then we've repaid the debt in full, on the other hand, by issuing an irredeemable promise to pay, which forces...
Just like they do.
Yes. Which we're not claiming to resolve the debt, but to resolve the falsified debt. You see? So we're pleading for our first 3 planks, which is to resolve our promissory obligations to each other to the only rightful state thereof. So, with all that in mind, we understand the scenario that this letter is being sent in. But it's being sent to people who may not even understand this obfuscation. This letter then is exposing it to them. Tacitly, at least, or implicitly, it's a shot across the bow. It's a warning, tongue in cheek, of what we want to go to court over, tempting the banks to try us. Hopefully, what we want is to go to court. We want to go to court because these letters actually expose our entire strategy. You couldn't, I mean, if there's no tricks to be played. We're not, this isn't a gimmick to get out of debt. It's arguments that resolve our debts to the only rightful state thereof, which resolve 90% of the world's debt. Plus, it's probably the high 90s, very high 90s, in fact. So, anyway, all that in mind, think about these words as you would receive them if you were the banking system. I'm certain that this letter and other letters that I do like it are relayed across the banking system. What are we going to do about this? What are the best ideas that you have? The central bank is going to say, don't you dare take these people to court. Because if this case is tried on the grounds that they're raising, the whole ruse is up. We lose this power to obfuscate their promissory obligations into falsified debts to us. We lose this power to dispossess every country of the world by an obfuscation of their currency, which inevitably precipitates in terminal dispossession and dysfunctionality. We lose this. Here's a check for whatever they owe you. Shut up. Don't go to court. Leave them hanging in limbo without closure because you go to court and we all come down. And you're going to pay the price for that. So this letter is effectively turning banker against banker against banker behind the scenes thinking, what are we going to do? In fact, it was after I sent this letter that you started hearing about bankers all over the world committing suicide.
Bingo.
So this is the letter. I send this letter 2 days after the Vandebrands are notified in person by a woman flying from Netherlands, the woman I write, that they'll be out of their home within a week. They got 5 days left when she gets this letter. Her name is Inga Moonen. So, without further ado, Dear Mrs. Moonen, I have been granted power of attorney regarding the matter of ABN AMRO versus Carl and Sue Vandebrand. I look forward to resolving related matters, and over the next few days, I do intend to furnish an initial response to the position of the bank, as much as the bank's implicit position can be understood from circumstance and given information. That sentence puts into perspective a fact that the arguments for what must be their claims, if they're claiming payments have to be made of principal and interest, the arguments don't exist anywhere in the world. And I've been researching this with the help of many people for almost 50 years now. I look forward to resolving related matters, I say, and over the next few days, I do intend to furnish an initial response to the position of the bank, whatever that is, as much as the bank's implicit position can be understood from circumstance and given information. Lacking any further given information, then all that can be understood from is circumstance, the implicit position, which of course is no legal argument. I understand that contractual obligations may be asserted to exist, which essentially then must derive not only from ostensible agreements between ABN AMRO and other banks in the assumable transmission of ostensibly lent monies, but most importantly also from commensurable consideration originating in faithful performance of a public trust inherently existing in the ostensible creation and acquisition or transmission of money by and between the banks of banking systems. I would be much obliged, therefore, for immediate, full, and faithful disclosure of ABN AMRO's prior knowledge of the trust it may or may not even agree exists in the proposition that money can indeed rightfully be lent into existence. Specifically, we desire to know without confusion, evasion, or equivocation how it is that banking contends it creates money as purported debts to a purported banking system which may or may not even give up commensurable consideration in the process. This, after all, is something we would expect you already know from such plentiful and faithful documentation as legitimate enterprise would already have provided. Thus it is, nonetheless, that we hope we may understand with appropriate certainty that such consideration as each resultant debt is indeed conveyed, that truly legitimate arrangements ensure to an actual creditor, who indeed gives up property for promissory obligations, that the representation of entitlement, which money must in turn represent then, is ensured to every actual creditor, of which the bank cannot be one, and furthermore, that it is both possible and practical under prevailing conditions for resultant obligors to fulfill their natural obligations to every such actual creditor, when in practice they might only sustain a necessary or vital circulation by a perpetual escalation of borrowing, in which principal and interest only return to circulation as irreversibly escalated and therefore inevitably terminal sums of otherwise falsified debt. In other words, given such global conditions as would corroborate such projected consequences, we are further concerned that the implied obfuscation of our promissory obligations to each other indeed inevitably precludes fulfillment of whatever contractual obligations banking otherwise might only claim, utterly without legitimate grounds. Given the grave ramifications of an irreversible multiplication of falsified debt, then, it is of course also important, this is our second question, first is commensable consideration. It is of course also important in the affairs of truly self-governed people that it can be demonstrated that already existing and assumably self-evident justifications of these processes are prior public knowledge, and that such prior public knowledge has indeed conferred truly knowledgeable public assent. Necessarily, then, the both must be comprehensive, not only of the prospective lack of commensurable consideration, but also of every potential implication. That would be including inevitably terminal monetary failure, dispossession, and dysfunctionality then. Thus, assuming the evident volume of the requested material imposes no excessive burden, because all that they require to provide these answers, if they exist, is to point us to where these accounts are that justify either question's answer in history. Thus, assuming the evident volume of the requested material imposes no excessive burden, we also desire all the information you can provide as veritable testament to knowledgeable public assent. I thank you then, not only on behalf of myself and the Vanderbrands for your kind assurances regarding each of these vital dependencies. I thank you furthermore on behalf of all deserved citizens whose well-being indeed depends upon their sovereign right to knowledgeable assent. Warm regards, Mike Montagne. End of contest.
Great stuff there.
Yeah. So commensurable consideration is the Achilles heel of the fraudulent centralized banking system.
That's what it all comes down to. And a debt does precipitate. We have to understand that. We have to understand that debt is no injury against us. It's no injury. That Paul Grignon has been selling videos. Money is debt 1, money is debt 2, money is debt 3, mad 3. Never. It's his misunderstanding that debt is the problem. You're looking at the end result is a terminal sum of falsified debt.
Right. Cart before the horse.
The problem is that the falsification of the debts, the obfuscation of the debts, of our debts to each other into a falsified debt to the banking system is a lie that allows them to pretend that the principal is at stake, thus purportedly lending us money from their legitimate possession into existence, which legitimate possession cannot exist as representation of entitlement because they never gave up commensurable consideration.
Right.
But it's the unjustifiable imposition of interest then, as if the principal was at stake, which precipitates in terminal dispossession, the form of which and the means of which are terminal escalation of falsified debt by interest. It's interest that is the second crime of banking. But we cannot forget that the first crime is to launder all the principal ever so malcreated into the unwarranted and unjustifiable possession of the banking system.
Mm-hmm. So possession and dispossession, irreversibly escalated debt fraud.
There you have it.
Amazing. Thanks so much, Mike. Do you have a website?
Yes, 2 of them.
Oh, I'm the first monetary reform presence of the modern internet. Yeah, you bet I do.
All right.
Perfecteconomy.com is original web pages is still preserved in a state they were in a long time ago, just as a historical record. And the new site where you can sign this global amendment is perfectedeconomy.org.
Great.
Awesome.
Great.
We also have 2 Facebook groups, Student Debtors for Mathematically Perfected Economy and People for Mathematically Perfected Economy at Facebook. You can join those groups where we have ongoing discussions